the conveyancing stage of litigation, which is, okay, we're going to take it to court, we've got to file the right form, we've got to brief the right barrister, we've got to get the right expert report, we've got to draft the right pleadings. And that all is obviously important work, but none of that work, as crucial as it is, does anything to improve the value of the case. The real value when you're a lawyer, in my mind, is, or should come in the middle, inspiration. There was an argument that just kind of marched into my subconscious and appeared, and I was like, that's it. That's what we're going to say. Coming up with that sort of idea strengthens our clients' arguments to the tune of, as I said, hundreds of millions of dollars, strengthens their negotiating hand. And so if they did ultimately elect to negotiate and settle the case, strengthens the amount they ultimately get. And that's real value that the lawyer has delivered. The lawyer that comes in and slays the dragon, as Bruce McEwen says, which I quote, is the one that gets the glory. The media write-ups, the movies made after them, the person who sits in the back room going, yeah, I've looked at it and I don't think you have a case. Well, they might get paid, but they never get celebrated.
G'day guys, welcome to the Brothers-in-Law podcast. My name is Davidson. Next to me is my brother-in-law, Thomas.
Today we welcome our first ever guest to the podcast. He's a man that needs very little introduction here at Melbourne Law School.
Yeah, he's a construction law specialist, previously working for top law firms here in Australia. He's an author of the book Modern Litigation. He's a husband,
yes,
and also a tutor of contract law and construction law here at the Melbourne Law School.
Welcome, Sam Woff.
Yeah, Tom Davidson, great to be here as your inaugural guest on the Brothers-in-Law podcast. Absolutely.
Fantastic. Well, first of all, how was your holidays? How was the summer?
It was good, yeah. One of the benefits of coming from private practice to working at university full time is you get the benefit, instead of 4 weeks of annual leave, I think it evolved to almost 4 months of annual leave. And obviously there's different kind of administrative things that you're doing kind of in and around that, but it's very nice to get a very comprehensive break and enjoy the good weather. And my wife and I spent most of it down at the Surf Coast, sort of Torquay and Jan Juc, that sort of part of the world. And we had a great summer down there, and it's with mixed feelings, of course. I'm excited to be back at university, but it's also hard to let the summer disappear into the background as you get back into it.
That's right. I was down at Great Ocean Road as well, so
nice.
Camping in Torquay. So yeah, it was beautiful down there.
Yeah.
But we've got a list of questions, so hoping we can just maybe go down. We'll pick your brain to see what happens. Well,
absolutely.
Yeah, I'll start off. One of the reasons why we think you're an excellent tutor is that you sort of always orientate your students towards what's to come and what's important. I remember you you talked to us about clerkships, even in obligations.
Yeah.
First year, Sem 1. And I remember vividly, first contracts class last semester, you told us you sort of likened that final exam to a dragon. And then you told us, to turn our brains, to unsheathe our swords and slay the dragon at the end of the semester.
Yeah.
I didn't slay dragon. Thomas demolished the dragon. Not gonna lie, but
Look, you clipped it, Davidson. Exactly. You damaged its wings. That's right.
I did okay. So I guess our question is, what has been some of the biggest dragons you faced, and are there any sort of dragons that you're facing now?
Look, it's a great question. In terms of dragons that I'm facing now, compared to the challenges that law students go through over the course of their journey, my dragons are relatively minor by comparison. I'm lucky enough to have already had a really great career, whereas you're all sort of working hard to try and get your foot in that particular door, and that's an enormous challenge. So for me, the first dragon, obviously, that comes to mind in this context is my own journey through law school and ultimately securing a job at a top-tier law firm, which was always my ambition, and I was very fortunate, as well as very proud to achieve that, because that's ultimately what it is, right? There's a degree of things when you go through university that are wholly within your control, and you conquer those with a sense of pride. But there's also, an irreducible element of luck that comes into it as well. Law firms aren't in the business of just ranking all of the students from highest achiever to lowest achiever and then taking the top 40% to go work at a firm. It's far more multi-dimensional to the decision than that. And once you get away from that pure numbers-based meritocracy, inevitably there's a degree of luck that plays into that final decision, because it's based on impressions, it's based on opportunities, it's based on even silly things like whether or not you clicked with somebody. And so I'm very mindful of that and very grateful for the luck that played my way, but also, not wanting to show too much false modesty. I'm also very proud that I put myself in a position where the luck could play out in my favour. So getting through law school and getting a job at the end of it was one of the most significant things that I'm proud of in my life. Also, there's another, going back a little bit further just in academic world, and this is obviously almost ancient history now, but when I was in year 12, I had such high expectations going into that particular year, and then I got to the mid-year exams, and through a combination of just being stressed and overwhelmed, I stuffed them up. Not in a major way, but in a way that I wasn't particularly happy with, and that was very difficult to overcome at the time. But one of the proudest things that I can say about myself is that I picked myself up, dusted myself off, got back on the horse, hit the books, and by the time I got to the end of year 12, was able to make up the deficit from the mid-year exams and ultimately end up with a really great score that I was happy with. So they're sort of historical dragons, I suppose, Davidson, to answer your question, that I've been proud of conquering in the past. And in terms, as I said, in terms of now, I'm fortunate enough to be in a really great place where I'm loving what I'm doing, teaching at the university, and it's a good mix of challenging as well as enjoyable. I wouldn't elevate it to the level of current dragon that needs to be slayed compared to those sort of more historical examples that I have.
Yeah. Well, it's the competition's fierce at Caulfield Grammar, I think you went to for high school, and also
right.
Melbourne Law School.
Yep.
I remember the first class, you sort of gave us like an anaphylactic warning, like this is the Olympic team, guys. Like you don't be too, I guess, downtrodden if you get like a grade that you're not particularly happy with.
Yeah.
So
the ego adjustment that comes with law school can be one of the things that is
felt it.
Yeah, is real. I mean, it's so challenging.
Transitioning from undergrad to law school,
Yep.
it's, not too hard to get pretty decent grades in undergrad.
Yep.
And then you go into law school and everyone there is used to getting fairly decent grades.
Yeah.
And all of a sudden, if you're average, you're like, well, oh no.
Yeah, no, that's right. And one of the reasons that I mentioned that up front in a, as you say, prophylactic way is just to get ahead of it, because otherwise, if you don't have someone sort of sit you down and say, you need to just be mindful of your expectations, you can get that first result back, and you can really go, oh my goodness, like what went wrong?
Yeah.
Can I not do this? Am I not suited to law? And that's with time you'll come to realize that's the wrong attitude to take. It's just the law school is on a different spectrum in terms of the bell curve. But if you don't have somebody telling you that in advance, you can take that first result really hard. And it's tricky as well, because that first result often comes at about week 5. The excitement of law school has abated a little bit, and you're sort of settling into the run of things. Daylight saving has stopped. It's getting darker. There's just a variety of factors. I remember when I got my first result back, it was a criminal law. Criminal law open book test type of thing. It was only worth 10%, and I got a 68, and it was at that sort of week 6 mark. Daylight saving had stopped, and I was feeling tired, and it was just a kick to the guts at the time. And I certainly don't want any of my students to feel the same way for getting a 68, which, as you both appreciate now, is a perfectly commendable and decent mark. For no other reason, as my colleague Wayne Josick tells me, if you get a 50 in any subject, you're legally qualified to be a judge in that subject.
Wow.
It's not a small thing to get a 50 in a law subject, because it means you're legally qualified to be a judge. Just like it's no small thing to finish an ultra Ironman. You finish, and that's a really good achievement. But yeah, I mean that sort of ego adjustment that you need to be mindful of going into law school, I think is something important just to be ahead of the curve on in terms of students' expectations. Otherwise, it can be pretty shattering. I mean, I'm not sure how you guys have dealt with it, but that realization that the era of 99s is now behind you and you're settling into a different era can be a bit difficult to sort of grapple with.
Yeah, semester 1 was definitely... We have a few similarities. Get a grade, it's like, oh, it's okay. You get another grade, it's, oh, it's a bit annoying. Oh.
That's right.
And then, but I think I was able to kind of turn it around for semester 2 a bit. So, yeah.
That's right. And as long as you realise that, if you get a 75, that's really good. You don't want to be thinking of that as some sort of, colossal failure, which if you don't have that calibration explained to you can sometimes be how you feel.
That's why the first grade comes back and you're expecting, you've been getting your 80s, your 90s, or whatever, and then suddenly it's wow, okay.
Yeah, it's a
different grading
it's
system.
a different it's just a different it's a different world. Yeah, absolutely.
And the one that sort of made me realize that was Section 18. Good old Section 18. Misleading deceptive conduct. Yeah, that was a harsh midterm, to say the least. But yeah, it's sort of we sort of like I feel like Tom and I certainly gradually, I guess, got the hang of things a little bit more. And we sort of see how what law school's like, how to take exams, how to study.
Yeah, brilliant.
And we did pretty well, I think, semester 2.
Yeah, absolutely. No, you both did exceptionally well. You should both. That's a dragon. You should both be proud of. If not slaying, at least mortally wounding.
Absolutely.
Well, Sam, we'll have to ask you about sort of your experience in private practice. You've worked for different firms such as Minters, Cores, and Landers as well, I believe. So can you sort of tell us the overall experience in these top firms and whether or not there were any similarities or differences?
Yeah. Look, at one sort of ostensible level, the large firms do have a lot of similarities in that they all tend to be comprised of the same people doing very similar work, all drawn from the same educational backgrounds, all living in the same city and all sharing the same legal jokes, which we find obviously hilarious, but to everybody else, it's sort of lost upon them. So there's a great deal of similarity amongst the organisations, really just by virtue of the fact that the pipeline of people going into these organisations are so similar as well. Not only does law school often attract similar-minded people, the 3 years that you spend together with other law students tends to funnel you into a way of thinking and a way of viewing the world, which means that by the time you get to the end of it, whilst you still retain sort of the individual characteristics of who you are, from a professional perspective, you're very much kind of homogenous. And then you all go off to work at law firms and you start working in those sorts of environments, and that homogeneity just perpetuates as you go through that sort of place. So in my experience, there's a lot of similarities between the firms, but then of course there's also differences as well. Minters and Cores were a little bit larger, particularly Minters in terms of its footprint. The footprint is more of a global footprint. Cores is very much one of Australia's leading, if not the preeminent independent law firm in Australia. And then Landers obviously is a large organisation as well, but probably a little bit more on the smaller end. And the size of the organisations tends to influence in subtle ways the type of work you do and the type of clients that you get and the type of problems that you're solving. So when you're at Minters, there tends to be an inevitable international aspect to the legal issues that you're dealing with, and then as you come to the more parochial firms, like at the Landers, say, end of the spectrum, it tends to be just from the clients that come to you and the background that they come from, the problems tend to be more Australian focused and domestic focused, and there's less of that international flavour with the types of work that you do. Having said that, I mean, my work as a construction lawyer, one of the great benefits of that is that construction law in a lot of ways is a very international field of work, in that because it depends, particularly at a commercial level, because the outcome of, say, a legal dispute depends so heavily on the precise wording of the contract that's been drafted and less upon the regulatory environment where the project was built, you can be a perfectly competent and indeed excellent commercial construction lawyer with very little understanding of, say, the domestic building regulations in Western Australia or in Malaysia or in Singapore, because they just don't tend to play as much of a factor when you're dealing with large commercial disputes. And so international construction law, or construction law, is a very international place where people can circulate around having debates about what the contract means, just like in contracts when we studied it. And that sort of knowledge of interpreting and applying contracts is relatively international, particularly across the common law world. Most jurisdictions adopt a pretty similar approach in terms of how contracts are interpreted. There might be minor differences, but they're all sort of singing from the same common law song sheet to an extent. Whereas if you're dealing with, say, domestic commercial or domestic construction litigation, that tends to be far more state-based in terms of its regulation. So here in Victoria, if you're building a house, obviously there'll be the construction contract, but that's just one element of a vast regulatory environment that you need to be mindful of when you're building a house and having disputes about houses that are being built. Whereas if you're building an oil rig off in the Tasman Sea, the contract tends to be, by and large, the main thing that governs the parties' obligations and the parties' rights and liabilities.
In terms of when you were working as a construction lawyer, was most of your work, I guess, domestically focused, or was most of it internationally focused? Because I remember you spent some time in Shanghai as well, learning Chinese when you were in high school. So I was wondering, did that sort of come into play?
Yeah, I always hoped that it would. It didn't. That sort of Chinese language, which I studied at high school and then also at university as well. I always had a sort of vague ambition that would be something that I would kind of combine with law, and I would, I had sort of these vague ideas of working in Hong Kong or Shanghai, these sorts of places, doing something with the law. It's not really how it ultimately played out. But that doesn't mean that I didn't get sort of an international experience with working as a construction lawyer as well. The projects that I was lucky enough to be involved in very much had an international flavour. So one of the largest disputes that I worked on had a owner who was from the United States and had a construction contractor who was from Europe, and they were building something in one of the states in Australia. And so that very much had an international dimension, if for no other reason, just very practically, the lawyers involved came from very different legal cultures. So you had the American lawyers who were not quite the caricatures that they're presented in movies, but there's certainly of that flavour. Like there was a bit more brashness in the way they practiced law. And then the European lawyers were very much what you would maybe expect, a little bit more reserved, a little bit less adversarial, having not grown up in an adversarial type system. Obviously, they've got an inquisitorial system in Europe. So that clash of cultures was interesting, and gave our work sort of a very sort of, at times, glamorous internationalism when you are otherwise just ploughing through documents trying to figure out why a pipe's got a crack. Getting emails from different parts of the world sort of gave that a bit of glamour to your otherwise day-to-day work. So that was quite cool. So I never got to use the Chinese language, unfortunately, Davison, and at the moment, my Chinese is terrible. It's heavily degraded. I suppose all languages have a pretty short half-life, and my half-life of Chinese has been very, very short indeed, which is a shame because obviously you spend a lot of time learning it. I don't know if any of you or either of you studied languages when you were at school, but you spend a lot of time developing that skill, and then you don't think about it for 3 years, and suddenly you find you can't put two sentences together.
It disappears.
Yeah, it disappears very quickly, which kind of feels like a shame. Because I really did enjoy, not only learning Chinese was enjoyable, but also the opportunities and the doors that opens for you. Being able to travel in China and have sensible conversations with people was a really, really interesting and cool thing to be able to do. Yeah, I never tired of that.
I also learned Chinese in university.
Oh, perfect, yeah.
Did a French in high school as well. I did year 12 French.
Okay, yep.
So that's gone now. So, Did you learn any languages?
Yeah, I did a bit of German, which again, doing a bit of
Good.
Duolingo, but yeah, it's Duolingo isn't quite the same as actually speaking the language, so it's hard to maintain it.
Look, and it's obviously much easier when you're living in a particular country. When you're living in Australia and you're working in Australia, just the force of the pervasiveness and the ubiquity of English just tends to drive any other language from your mind. Whereas if you're living in, China, or if you're living in Germany, I'm sure just by necessity you would keep a little bit kind of in reserve just to sort of be able to navigate life in a sensible way. Yeah, it's been great. It's been a really, really invigorating shift. So I really enjoyed my work as a lawyer at the firms I was working at, and I did it for quite a few years, and that's usually the proof is in the pudding there. If you stick with something, then usually that means that it's going all right. And it's funny because it wasn't an intentional shift. It was really just an opportunity that came up. One of our colleagues here at the law school invited me to come down and teach a class just on an ad hoc, one-time basis. And the moment that I did it, I was like, wow, that was so much fun. I really, really, really enjoyed that. And then gradually, I wanted to do more and more of it. And then I found that I had reached a tipping point where I was doing more of that than working as a lawyer. And I thought, well, that's probably telling me something in terms of what my priorities are right now. So maybe I should give it a full-time go. And it's been yeah, like I said, Tom, it's been invigorating to do something with the law, but that is different from what I've been doing for the last 10 years, and far more interactive in terms of the teaching of students. You tend to be grappling with legal concepts on a very quick fire basis, whereas in practice what I would find is you would, and neither of these are right or wrong, but in practice I'd find you would go deep into a particular issue and spend a couple of months on that one particular issue. Whereas when you're teaching, obviously, you don't have the luxury of going into that depth, and you need to be able to pivot to different topics and different discussion points and different principles, because you need to fit, obligations into a 12-week time frame. So you just don't have the luxury to be able to go in depth, and that's been enjoyable as well, sort of approaching law from a different perspective and a far more interactive perspective.
Yeah, you definitely seem passionate as a teacher, and I think we've both already told you, you kind of set the bar for our law school education. We wish all our teachers were like you. Your classes are enjoyable, engaging. You make us all want to show up and learn.
Thank you, Tom. Thank you, Dave.
Yeah, I mean, you said that you're trying to give us what you wanted to have as a student.
Yeah.
So how do you develop this stuff?
Well, yeah, I mean, that's, given that I come from this without, I obviously had 10 years as a lawyer, but no sort of formal education in educational training. I really was just trying to work from first principles in terms of, how would I go about structuring a lesson and structuring a course? And what I kept coming back to was, what would I have wanted? I'm coming to this for the very first time. I know nothing about contracts. I've got a vague sense of what an offer and acceptance is, but once you've got me at consideration, I'm lost. And so, what would I have wanted in that situation? How would I have wanted it explained to me? What introduction would I have wanted? What analogies would have worked for me? And then I use that as the base for going into the class. And then, most of the time I find that works pretty well. Sometimes something you think will work in your mind doesn't quite land in the way that you expect it to, and that's okay. That's part of the fun. You sort of try something else, or you pivot around to a different angle. But I figure that if I start from the premise that if I present the class in the way that I would have wanted it, then that's a pretty good starting point. Not that I represent the Cheltenham Omnibus law student and everyone's exactly like me, but in the absence of anything else to go on, I thought that was a good starting point, and that seems to have worked pretty well.
Yeah. You certainly have a very unique teaching style. And tell me if I'm wrong, I've noticed that when you sort of read a case, in terms of just law subjects, it's very linear. When just reading cases, very much just reading line by line. But I think with you and the use of diagrams and different images and things like that, I kind of see the chemistry student a little bit. Am I just seeing things, or?
No, definitely not. I loved chemistry when I was at high school, and in a sliding doors moment, I would have gone down a completely different path. I would have been a doctor, but that's not ultimately that's not really what fate had in store for me. So, but that idea of approaching law through the prism of law obviously has a lot of text. There's a lot of reading to be done, and that's obviously important, and being able to digest written material is obviously a key particularly common law skill. But when you are trying to explain a concept, just sitting down and reading 3 pages of text written by a judge who's not always the best at getting to the point and explaining what they're trying to say, doesn't always, I think, convey the information as efficiently as it could be. And that's why I'm drawn to, well, how can I take the information that's embedded in this document, and there's valuable information there, and there's ratio, and there's rules, and there's principles, and there's observations, and how can I, in a more visually appealing way, illustrate what's going on here in a way that doesn't require you to do your own mental gymnastics in your mind, which is just read it and then kind of try and figure it out yourself. And certainly there are no substitutes for a close reading of the cases, and no substitutes for a particularly close reading of the statute. But as an aid to explanation, I think that they've got a lot of power. And that's why I like to use them, Davison, because I think that they're able to convey information in a intuitive way relatively quickly.
I don't know about you, Tom, but I would love to hear about the $1 Million Lunch.
Yeah, so tell us a bit about this story that you briefly mentioned in your book.
Yeah, so it's as part of the chapter on the importance of coming up with better arguments as the real key defining feature of what makes a lawyer valuable. So with all litigation, you've got what I refer to in the book as the valuing step, which is you get all the information from the case from the client, you combine that with your knowledge of the facts, knowledge of the law, and your knowledge of how things are likely to play out. And in your mind, even though you might not articulate it expressly in a value, you're starting to think, this is a good case, this is not a good case, it's probably worth kind of about X. If I was to settle it, I'd probably be around this ballpark. And then you've got what I refer to as the conveyancing stage of litigation, which is, okay, we're going to take it to court, we've got to file the right form, we've got to brief the right barrister, we've got to get the right expert report, we've got to draft the right pleadings. And that all is obviously important work, but none of that work, as crucial as it is, does anything to improve the value of the case. All you're doing is putting your house or putting your case through the necessary conveyancing steps which are necessary to turn it into cash. The real value when you're a lawyer, in my mind, is or should come in the middle, after you've got all the facts, but before you start putting it through the sausage factory to take it to court, sitting down and thinking quietly, what can I do? How can I come up with some arguments that are going to improve this case? What, if I had, 30 seconds in front of the judge, what am I going to say? What's going to be my hardest hitting point? And that sometimes comes from just reading the case and reading the facts themselves, but often more and far more common comes from inspiration. You said that you were out on a run once and you solved a complex physics equation. Oh, sorry, that was Tom. Yeah, you solved a complex physics equation just being out on a run. That's an example of this sort of inspiration I'm talking about, where it's not something that you could sort of consciously sit down and kind of necessarily work through and come up with the best possible legal answer. But when you're quietly doing something else, you're out on a run, you're swimming, you're doing yoga, whatever, something strikes you. And often I find the best ideas you have for work are away from work. And that's really what the story was about, sitting back and having lunch. I'd been working all morning on a particular problem and making some progress, but it's not until you sit back, relax, grab a sandwich, look out the window, let your mind wander, that inspiration comes to you. And that's exactly what happened. There was an argument that just kind of marched into my subconscious and appeared, and I was like, that's it. That's what we're going to say. And it meant that, not to bore anybody with the details or go into things that are confidential, it meant that one contractual pathway that our client was seeking compensation through suddenly opened up. So an entirely new basis of claiming, which is an incredibly valuable thing for our client. Instead of only being able to rely on a single legal argument, they now got two. And depending on the strength of that second argument, that might very well improve the value of their case from a settlement perspective by, well, this case is quite a large case, so in this case's instance, hundreds of millions of dollars. Wow. Now, I shouldn't overstate my role in all of this. I was working on this case as part of a team. I certainly wasn't the only person in charge. But coming up with that sort of idea strengthens our clients' arguments to the tune of, as I said, hundreds of millions of dollars, strengthens their negotiating hand. And so if they did ultimately elect to negotiate and settle the case, strengthens the amount they ultimately get. And that's real value that the lawyer has delivered. It's not just taking the case and providing advice, which any competent lawyer should be able to do. And it's not just taking that advice you've given and putting it through the necessary process to take it to litigation and seeing how it plays out. Competent lawyers can do those things, and it's important work, but it doesn't do anything to increase the value. And my point in the book, which I hope sort of accords with common sense, is that if you want to increase the value of the case, you have to lean far more heavily on inspiration rather than busy work. And that only happens when you're kind of kicking back and taking time to relax. The problem, of course, with that, as I say, is that from the perspective of the billable model, that's not a good fit, because the billable model encourages, steady, consistent work, 7.5 hours a day, 8 hours a day, and kind of kicking back and having a sandwich at lunch, thinking things through, it's a bit hard to put that on the bill as being something that you can charge for, and that's completely appropriate for most legal work. But I think the slight prejudice with the billable model is it doesn't sufficiently value those moments of inspiration because they happen in an instant. And if you were to charge for an instant's work, like it would be worth fractions of a cent, even though that's where the true value lies.
Yeah.
But like I talk about in other parts of the book, I don't think we're moving away from the billable model just yet. So we just kind of have to grin and bear that disconformity a little bit. But I think that idea of bringing some additional inspiration to our work as lawyers is an incredibly important one, if for no other reason that it increases the value of the work that we do.
No, it's fascinating. And as long as you were able to charge them the cost of the sandwich, then it's all good.
Yeah, that's right.
Can you imagine? Lunchtime.
$5.
That'll be $100 million I made.
Right, exactly. It's a very, I think, as I said, it's a very, very valuable sandwich. No, I think I bought the sandwich myself, so.
Oh, fantastic.
In the first chapter of the book, you also just sort of discuss the difference just generally between advocacy and advice, and use a metaphor of fire and ice. So tell us a bit about that.
Yeah, so that's I'm really glad that you picked it up, and it's obviously one of the key metaphors that I use for that. So, I mean, the book is approaching the work of a lawyer, in particular a litigation lawyer, and the first thing that in my mind you need to make clear, and this is really for your listeners rather than either of you because I know that you've read it, is you need to be clear in what frame of mind you're operating as a lawyer. The client comes to you for advice. Are you being their advisor or are you being their advocate? And often we conflate those ideas. You know, lawyers will say, I'm an advisor and an advocate, but they're actually two fundamentally different processes. One is the advisor, like you say, is about being cool like ice, seeing things dispassionately, weighing things up, and ultimately making a cool and calm recommendation about what to do. And a good advisor should never allow passion to influence that ultimate decision. Whereas a advocate, on the other hand, I would argue that a degree of passion, not hysterics, not tantrums or anything like that, but a degree of fire, a degree of passion is necessary in order to be a good advocate. Because if you don't believe in your case, why would the judge? And so that passion that makes you a good advocate can also be the same passion that infects the advisory role. And so in my view, you need to keep the roles completely distinct, because if you're passionate when you should be advising, the advice will be wrong. And if you're too cool when you're advocating, your advocacy won't be persuasive. And so the point that I make in the book there is that whilst it can be tempting to try and do both, really they should be segregated out, and people who are giving advice and people who are in charge of the advocacy, ideally in an ideal world, should be different people, because the skills involved are completely different. And it's very hard to, if you're normally a fierce and passionate advocate, it's very hard to turn that off and go, right, okay, now I'm going to just cool it for a bit and see things dispassionately. You might say that you can do that, but I think that it's just very hard to regulate yourself to that degree of specificity, depending on the circumstances.
It's very interesting. I think reading that chapter, I sort of slowly realised that I'm certainly an advocate.
Yeah.
Because I just feel like last year I did a lot of mooting.
I can see that, Jason.
Yeah, I felt like when I was mooting that courtroom and a judge was in front of me, I just sort of felt myself come alive.
Yeah, for sure. Exactly. And that's that passion that I'm talking about. And I'm sure that you felt that when you got on a roll and you were making your point and you were driving it home, you did feel a little bit like, and this is the other analogy I use, like someone in battle, someone fighting. And you'll bring that passion as a tool of persuasion, and that's obviously really, really important. But it would be difficult for you to then step back once you've finished that impassioned submission to the court and make an impartial judgment about how strong that argument is, because you're in the weeds of it. Yeah. You've drunk the Kool-Aid.
That's right. It's black and white.
Yeah,
it's case closed.
It's case closed. And then when it comes to you sitting back and going, how strong is it actually? Yeah. Even if you're making a Herculean effort to try and be impartial, the flames of passion are still there, which inevitably mean that you overvalue how strong your argument is.
Yeah, I think Tom said you're more of a...
Yeah, well, I also enjoyed mooting, and you're talking to someone who's pretending to be a judge, and you're expressing yourself, and the heart rates start going up, and everyone's getting a bit tense.
Yeah, of course.
But I feel like I'm probably more of an advisor. I don't know for sure, but I think I'm probably more of an advisor.
Yeah.
But I was hoping to ask you, like, at your core, who are you?
Yeah, great question. At my core, I think that I lean towards advocacy.
Yeah.
I lean towards advocacy. If only because that's when, when I'm making a point or I'm driving an idea home, that's when I feel alive. And it can be hard to sort of sit back after that and go, you know what, actually I don't know if that was that persuasive. I just don't have that kind of ability to be so self-critical. And I think that's true, like I say in the book, I think that's true of a lot of lawyers, that we tend to gravitate towards that. And that's interesting, Tom, that you sort of recognise that maybe that's not you. And that's quite interesting. Many of the lawyers that I worked with subconsciously lean towards the advocate side of things for a variety of reasons that I point out in the book, if not only for the reason that that's often where the professional glory lies. The lawyer that comes in and slays the dragon, as Bruce McEwen says, which I quote, is the one that gets the glory. The media write-ups, the movies made after them, the person who sits in the back room going, yeah, I've looked at it and I don't think you have a case. Well, they might get paid, but they never get celebrated. And so if you're sort of searching for that external validation, which, to be frank, many of us are, including myself, even at a subconscious level, you want to be the person that comes in and wins the case, the hero. And it's harder to be that when you're just handing out advice, as important and as valuable as advice is, and as necessary as it is.
If I want to be the hero, I'm going to have some pretty good sandwiches.
Yeah, that's right. That's right, yeah. I think it was a cheese and tomato one, so I don't know if there's maybe not causation, might just be correlation. Yeah, that's right.
Yeah, because like when we see on TV, it's always the Michael Jordans who's scoring the goals, right?
Yeah.
But there's always that,
Yeah, for sure.
what's the word? There's the person on the sidelines who's actually making it happen. It's not just Jordan himself.
that's
It's-
right.
Jordan himself can't take the team to victory.
Yeah.
Yeah, but he's the one in the spotlight, right?
Yeah.
We're just wondering, you've been such a fantastic source of wisdom and inspiration, certainly for all your students and definitely for us.
Yeah.
I was wondering how, throughout your career life, who has inspired you? Who do you go to for advice?
There's one person that comes immediately to mind, which was a teacher that I had at high school, who really was that sliding doors moment. So I said that I was heading down the medicine. I was thinking kind of sports medicine sort of angle, and then I did legal studies in Year 10 with a teacher at Caulfield who's no longer there. He works at Victoria University now, David Thompson, and he was a former barrister who came back to teaching because he just enjoyed it so much, and he taught me legal studies as well as English in Year 12. And he was a phenomenal influence on me. He was the one that triggered that hitherto dormant realization that, yes, I want to be a lawyer. This is for me. I love this. He got me involved in mooting at high school, which compared to where I am now, I look back on the moot that I did at high school, and it was hopelessly inadequate. we had one case on, I think it was the duty of care of teachers for some bullying in the playground or something like that, and I made an absolute mess of it. But nonetheless, it was enough to inspire something in me that meant that from Year 10 onwards, it was always going to be law. And so in terms of the inspiration and the influence that an individual has had, he stands head and shoulders above all the others.
And is he the one who wrote the foreword?
Yes, he is. Yeah, he is.
sounded familiar.
Yeah, he is. He did write the foreword, and I thought that was completely appropriate because for me that was full circle.
He
Given-
was the foreword to your legal.
Exactly. Yeah, it was very symbolic in that sense, I suppose, as well.
Excellent. I had a good relationship with my English teacher as well in high school.
Yeah, I can
certainly-
see that.
Yeah, I was definitely not a math student. Tom is a math gun, absolute math gun. But yeah, I was certainly more leaning towards English and literature in high school.
But that's the interesting thing about law, of course, isn't it? That it's actually an interesting blend of the maths and the science plus the linguistics and the language. Obviously, it's heavily rule-based, which leans into people that prefer science and mathematics and physics and those sorts of things. But then there's an irreducible element of flair and argumentation and persuasiveness, which people that are sort of from a science background sometimes find a little bit challenging because they're used to thinking that there's a single correct answer, and in which case, in a mathematical problem there is. But when you're trying to deal with questions about the meaning of a word in a contract, there are obviously disputing views about what it means, and trying to, it's never a search for the right answer, it's a search for the most convincing answer, or the answer that can galvanise enough judges to outweigh the other judges.
Interesting. Yeah. Would you agree with the old adage? I think it's something like, if you ask a teacher what's 2 + 2, the total is 4. If you ask an accountant, they'll get out the calculator, they'll put in 4. You ask a lawyer, they turn the blinds off. Right? They make sure no one's here. I was like, what do you want it to be? Would you agree? I'm not sure if you've heard this.
Yeah, I haven't heard that one. I thought you were going to go with, if you ask a lawyer what 2 + 2 is, they say it depends. But that's where I thought it was going. What would you like it to be? Yeah, look, there certainly can be, I suppose with any advice, any sort of service where you're giving advice, one of the hardest things to do can be to give advice the other person doesn't want to hear. Particularly given that they're the one who is paying you, and if you tell them something they don't want to hear, they might stop paying you. So you've got a fiscal interest in keeping the client happy, and that can make it very difficult to give truly impartial advice. Although, all lawyers are alive to that moral hazard, and I don't see any real suggestion that by and large lawyers don't try and do their best to give fearless advice. But that is always a looming challenge that can be hard to give unpopular advice, particularly if you want to continue to have that person as a client.
Absolutely. Yeah, I'm not sure if you've ever thought about, because I just feel like the age of social media, the age of internet, you can reach so many more people. Like, have you ever thought about becoming more, I don't know, having more of a presence online in terms of your teaching?
Yeah. So it's interesting. When I was working as a lawyer, I used to have a fairly active social media presence, and then since I started working as a lecturer, and I suppose that social media presence just hasn't been maintained to the same degree, really because there just hasn't been the same need to. When you're working as a lawyer, one of the things that's obviously really important is maintaining a reputation and maintaining a presence in the market. And the best and most efficient way of doing that is, like you say, social media and having a presence there. Since I've stepped away from that commercial imperative, I've found that there just hasn't been the same pressing need to maintain a social media presence. But I do agree that there is a lot of power. There's a lot of power in it, and law students and lawyers that can harness that really set up their career for a lot of success. And that's why this is quite useful for, I think, for the both of you as well.
I think maybe one last question.
Yep, absolutely.
Who should we talk to next?
Oh gosh, maybe we'll have to edit that bit in. I'll have to have a think about who would be useful to talk to next. Well, you've spoken to me, who's someone who's kind of straddled the commercial sphere and then the university sphere. So possibly somebody from a completely different background, someone who's in criminal law or personal injury law or family law or something like that. But I'd have to get back to you with a particular name as to who it could be.
Fantastic.
All right. We look forward to it.
Yeah, well, thank you so much. Yeah. Thank you so much for coming on the Brothers-in-Law inaugural podcast. I think it's been excellent.
It's been a real privilege. Just like it was a real privilege to have you both in class last semester, and I wish you all the very best with the new podcast. I'm sure it's going to be a huge success and a really good forum for some interesting conversations as well, which is a really good thing.
Fantastic. Well, thank you very much. Thank you so much.
All right, no problems. All right. Thanks very much, Tom.
Thanks, Sam.
Thanks very much, Sam. It's been a real pleasure.
All right.